If the jury is out deliberating in your medical malpractice trial and they can't reach a decision, can you go ahead and try and settle your case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, you can. You should know that you can settle your case at any stage in the litigation. You can settle it shortly after you start your case. You can settle it at any point in the discovery phase. You can settle it after you notify the court that your case is ready for trial. You can settle it during jury selection. You can even settle it while the jury is out deliberating, waiting for a verdict. Many people don't know that, but it actually is true. You can. Now, you should know that when that happens, when the jury is taking a tremendously long time to reach their decision, now both sides can get concerned and sometimes worried. There may be a concern that the jury is going to come back with a very significant verdict in favor of the injured patient. On the other hand, there may be a concern that the jury is going to come back with a very small, insignificant verdict for the patient or totally against the patient and for the doctor. And that may prompt both sides to come together to try and negotiate in order to try and settle this case and take that decision away from the jury. So it is possible to go ahead and settle your case, or at least try to negotiate while the jury is out. It's like going to Las Vegas and gambling at the table. You can take the dice, you can roll it, you have no idea what's going to happen. And unfortunately, when your case goes all the way to trial, you don't know what's going to happen. You don't know what the outcome is going to be. You may have the best case in the world. You may have horrible, horrible injuries and damages. And you may have great experts to support your case and your claim. And you know what? The jury may come back and says, sorry, we don't like you, we don't like your experts, we don't like something about your case, and therefore we're not going to give you a verdict in your favor. Or we're going to give you a verdict that totally destroys your expectations of what you think you should be receiving. And again, nobody, not the injured patient, not the attorneys for the doctors, nobody knows what the outcome is going to be when the jury goes ahead and now has to answer specific legal questions in order to reach their verdict. Now you might be thinking, what kind of questions do they have to answer? Don't they just come back and say yes or no, and here's how much money you get? No, that's not what happens with a jury. Instead, the judge gives the jury a very specific set of instructions. Ladies and gentlemen, you have to answer the following questions, and they must be done in order. You cannot go out of order. So the first question typically is, was the defendant negligent? Now what does that mean? It means, was the person you sued careless? In this case, in a medical malpractice case, it's the carelessness of a doctor, a medical professional. If the jury says no, your case is over and you get nothing. If, however, the jury says yes, the doctor was careless, now they have to go on to the second question. The second question is, was the doctor's carelessness a cause of your injury? If the jury says no, again, your case is finished and over and you get nothing. If the jury comes back and says yes, the doctor's carelessness was a cause of the patient's injury, now they go to the next question. And the next question focuses on what we call damages. How much money is the injured patient to receive for all of the injuries and harms and losses that they incurred? And there could be many different elements of damages, and I'm going to save that for another video. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize you're watching this video because in all likelihood you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.